A federal court in Oklahoma recently issued a decision in a life insurance beneficiary dispute that involves a couple of issues that I see commonly. First is designation of a former spouse as the beneficiary, and second, the doctrine of substantial compliance in a dispute whether or not an insured changed the beneficiaries of his life insurance policy. So the situation in this case was that the insured bought a policy while he was married, and he and his wife had 3 children. He had designated his wife as the primary beneficiary, but as contingent beneficiary, he simply listed also our children, a general description. Then he divorced and remarried, and with his second wife, he had 2 additional children. After he remarried, he notified the insurance company that he wanted to take the wife, his first wife, off of the policy, and he put that in writing. He also apparently indicated to an agent that he wanted to list the new children as additional beneficiaries of the policy, but he never filled out the appropriate forms to do that. So then he passes away, and the life insurance company filed the interpleader in regards to a dispute as to who should receive the policy proceeds. Now, everybody agreed that the ex-wife was not going to get the proceeds because Oklahoma, like many states, has a statute that says for life insurance policies that a subsequent divorce will invalidate a designation in favor of a former spouse. And the spouse is essentially treated as if he or she predeceased the insured. So, but the issue here was, did the children of the first marriage get the policy proceeds, or did the children of the second marriage? And the argument is that the children of the first marriage could not receive the policy proceeds because they weren't specifically identified in the policy. They were simply identified as a group, and the argument was, well, if the first spouse is disqualified, then her children should be disqualified. And the other argument was that they had effectively been removed when the insured notified the insurance company that he wanted to remove the former spouse, and then apparently told the agent that he wanted the children from the second marriage to receive the policy proceeds. Well, the federal judge decided that no, the children of the first marriage were going to get the policy proceeds. The judge did not have a problem with the fact that they were not specifically listed as contingent beneficiaries. Instead, they were listed as a class, the children of our marriage. The judge did not have a problem with that. And then the judge found that any statements to the agent were not good enough to designate the later children, that the insured needed to take more positive action, fill out the form, or send something more specific into the insurance company to let them know that he actually did want to change and add new beneficiaries to the policy. These can be very complex issues involving state and federal law. So if you have a beneficiary dispute in the United States involving life insurance proceeds, it's very important that you call a lawyer who is experienced in handling these cases.